Okay, welcome everyone. I can see we've got 57 participants. There may be a few more joining, so I'll wait just a minute and then we can make a start. Catherine, just checking you're there because you're not on screen at the moment.
Hello.
Great, great. All right. Okay, well, welcome everyone to the Garden Court seminar or webinar on housing conditions update and bringing personal injury claims. We're delighted to welcome two speakers, but particularly our guest speaker, Patrick Spence, who has been a solicitor for over 20 years. He works at Dowse Co. I'm sure many of you will be familiar with him, but he specialises in personal injury law in the context, both in a housing context and also in the context of cycle accidents and workplace accidents. But for the purposes of today, Patrick is going to be taking us through the conundrum that is the personal injury claim within disrepair claims. So we're very grateful to you, Patrick, for being with us this evening. There's also Catherine O'Donnell. Many of you will certainly have come across her book, even if you haven't met her in person. Catherine is a member of the housing team at Garden Court. She also does court of protection work. And of course, she is the author of the Housing Conditions lag book, which I'm sure you use frequently, as do I. I'm Justine Compton. I'm also part of the housing team in Garden Court. So without further delay, I'm going to hand over to Catherine, who's going to provide you with an update, and then we'll hear from Patrick, who will be dealing with personal injury elements. At the end of the speakers, we will be taking questions. So please do put your questions in the Q&A chat or the Q&A box, and then we will pick them all up at the end and we'll deal with as many as we can. So thank you very much, and I'll hand over to Catherine now. Thank you.
Thanks, Justine, and welcome everybody to the talk. My talk, I'm just going to share that with you now. My talk, which I'm talking for about half an hour or so, probably a bit longer, is entitled Housing Conditions Update, and is in fact based primarily on the update in that I produced for Legal Action, which is published in the February current edition. I won't be including everything. We don't have the time for that, but I wanted to use the time particularly to focus on what's arisen from the tragic death of Arab Ishaq. Because his death brought to national focus the terrible conditions in which many people live with damp and mould, and many of our clients have to suffer and have been living with for years. And at the same time, the way in which concerns and complaints can be ignored or minimised, and even where the resident, as in this case, can be blamed for the conditions that they have to live in. So what I'm going to do to start with is spend a bit of time looking at how not only what the results of the inquest were, but how the institutions which regulate the social housing sector have responded, and highlighting where possible how we may use those responses when dealing with landlords, particularly in the social rented sector, to push back somewhat against certainly the attempts to blame our clients for their conditions, and also to put more pressure on landlords to then take effective action and to take it quickly. And I'll be mentioning quite a few documents because there has been a flurry of activity. And I've included some hyperlinks in the slides, which when you get the copies of them, may not come out, but if they don't, please do contact me. I'm more than happy for you to contact me and I can send you the links. You may be able to find them through Google quite quickly, but I'm happy to help out. So I'm just trying to move on here to start with the inquest issues. So the inquest into the death of Al-Ishaq concluded in November last year, and it found that he died as a result of a severe respiratory condition due to prolonged exposure to mould in his home environment. And on the 16th of November, the coroner made a report to prevent future deaths under the coroner's investigation regulations. And that report was to the Secretary of State for Levelling Up Housing and Communities and the Secretary of State to Health. And she found that presence of mould had been notified to the landlord, Rochdale Borough-wide Housing, by Al's parents in 2017, before he was even born. And Al's father was told to paint over it. And then a further complaint was made in 2020 by the health visitor. The family instructed solicitors to make a disrepair claim due to the mould, and subsequently an inspection carried out on the 14th of July by the landlord confirmed the presence of mould, but the policy at that time was not to progress to repair and treatment until the agreement of the solicitors had been obtained. So no action had been taken on the mould by the time Awab died, and which is quite unbelievable, really, but unfortunately, happens all too often that years can pass before action is taken. During the course of the inquest, the Housing Ombudsman gave evidence regarding its October 2021 report, Spotlighting Damp and Mould. It's not lifestyle. And many of the themes the Ombudsman said it had noted from the increased number of complaints it received were found in Awab's case. And those things were too much emphasis on the cause of the mould being family lifestyle, lack of proactive action to consider wider potential sources of damp, lack of consideration of ineffective ventilation. In Awab's case, they had a bathroom which had no windows in it and a fan which didn't work effectively. There was no mechanical ventilation in the kitchen, and it had a window that opened onto a communal walkway. So that kind of restricts the amount of that it can be left open. So that was what the inquest heard. I'm just trying to move on. So the coroner then found it was a duty to report the matters of concern that she had distilled from the evidence that she'd heard. And there were 5 matters of concern. She found that the document, A Decent Home Definition and Guidance for Implementation, doesn't give any consideration to the issue of damp and mould, nor does it provide any guidance as to the need for a property to be adequately ventilated. The Decent Home Guidance applies to social landlords, and just as an aside, a decent home must be free of a category 1 hazard and in a reasonable state of repair. It's not something that you can apply in the court, the decent home standard. It's part of the regulation governing social landlords. She also found that the Housing Health and Safety Rating System data sheet relating to damp and mould used to calculate risks of the incident and spread of harm was reflective of the current known risks of damp and mould and harm to health. There was no evidence, there's up-to-date relevant health information pertaining to the risk of damp and mould that's easily accessible to the housing sector. And the evidence highlighted a policy among housing associations in cases where a disrepair claim has been brought of waiting for agreement from the claimant or their legal representative before rectifying any recognised disrepair. And of course, what as legal representatives we will want foremost is for the damp and mould to be dealt with. We may have issues about how it's dealt with, but we won't want to be stopping, unless, of course, it is going to make matters worse, the landlords to be dealing with it. And she also pointed out that as a matter of concern, the private landlord sector doesn't have access to the housing ombudsman for complaints to be investigated. So that was the report. What was the reaction? I'm going to move on to look at the response of institutions now. On the 20th of November, Michael Gove, Secretary of State for Levelling Up Housing and Communities, wrote to council leaders and social housing providers calling for action. I think, just pausing there, that the reason I've highlighted some of these quotes is because I think there's a real opportunity now to use some of what is said to use it when communicating with landlords to underline what their duties are and what is expected of them in these situations. Michael Gove said, all social homes must meet the decent home standards, and you must be aware of any that do not and undertake rapid remedial works. But in the light of this case, he would expect landlords to go further than the letter of the standard and have particular regard to damp and mould. And a footnote to that letter, that point, is written specifically, as well as category 1 damp and mould hazards, to have regard to and take action on high scoring bands D and E category 2 damp and mould hazards, as outlined in relevant guidance. He also said that damp and mould are not lifestyle issues, as the Housing Ombudsman Service underscored last year. Where people complain about damp and mould, you must listen. Where you find them, you must take prompt action. And it is the case, unfortunately, and I'm sure that practitioners among you will know, is that we all too often are still getting this allegation, this general, unspecified and unevidenced allegation of the fact that there are lifestyle factors involved, which means our clients are responsible. I think there's a clear warning here that this isn't an acceptable way for social landlords to proceed anymore. Further, on the 13th of January, the Secretary of State for Levelling Up and the Secretary of State for Health and Social Care responded to the specific matters which were set out by the coroner. And action the government said it would take included an amendment to the social housing regulation bill relating to hazards in social homes. What that specifically is, there's been this phrase used called Awab's law that you might have heard, and what the government is proposing is an amendment to the social regulation bill that will give power to the Secretary of State to publish a policy statement on tackling serious hazards in social housing. And what he said is that, and including damp and mould in the social rented sector, the policy statement would specify time limits which landlords must meet regarding investigating hazards and acting where there are health concerns. So that's one action that is going to be taken. There's also a current review of housing health and safety rating system. This was supposed to finish this review last year, but it seems to have been extended now because we haven't had the results of it. But anyway, it will include updated estimates on the likelihood of harm due to dampness and mould based on current research. If you look at the current guidance, the most up-to-date it has, and this guidance was 2006, was 2003, so 20 years later. None of that new learning on the effects of damp and mould has yet been included in the guidance. A rapid review of existing guidance on health impacts of damp and mould, and the creation of a new private rented sector landlord ombudsman through the upcoming Renters Reform Bill. And apparently the Renters Reform Bill is going to be in this Parliament. And also that the Secretary of State will be writing to legal bodies requesting their help directing social tenants with concerns about their housing to the Housing Ombudsman. you will have seen HILPA's response to this in legal action by Simon Mullins, co-chair of HILPA, who sets out cogently the difficulties with this approach. But also, in addition, of course, when clients come to us, we're limited by legal aid, and legal aid will only provide for disrepair where it's a defence and counter. So you can't go to the Housing Ombudsman and then wait to put in a defence of disrepair. But also when there's a significant risk of harm, in which case you can't really go to the Housing Ombudsman because they don't take urgent action, or they don't order urgent action. So it really isn't appropriate for the clients that we are covered to help to be just being directed to the Housing Ombudsman instead. Just on what's happening in what they're posing in the private renters centre, in the renters sector. This is going to be through the Renters Reform Bill when it gets going, which is placed before the end of this session, which is May 2023. They're going to legislate a legally binding decent home standard in the private renters sector. They say they've been running pilot schemes with local councils, trying improvements to the enforcement of existing standards and explore different ways of working with landlords, and also to introduce a single government-approved ombudsman covering all private landlords who rent out their property in England, which I referred to in the previous slide, membership of which will be mandatory, and local councils will be able to take enforcement action against landlords that fail to join. There has recently, second half of last year, been a consultation on the introduction of a decent home standards in the private rented sector, and includes consultation on the government's plan to introduce a legal duty on landlords to ensure their property meets the decent home standards. Who's going to monitor this? Well, local councils will do it through inspection, and if they're in breach, this will be a criminal offence and can be dealt with by issuing a civil penalty or undertaking a prosecution. It can failure to comply with this duty would also be potentially made a banning order offence, and they would be extending the grounds for rent repayment orders, requiring landlords to repay rent to the tenants in situations where they've not complied with decent home standards. And it's also consulting on who's the appropriate landlord in these circumstances. For example, is it in the area of rent-to-rent landlords? Is it the immediate landlord? Is it the landlord with control of the property? And also who should be included? Should it be all accommodations, or should it exclude such student accommodation or temporary homelessness accommodation? Moving on to the Housing Ombudsman's response, the Housing Ombudsman at the same time in November wrote open letters to social landlords about complaints of damp and mould, asking them to renew its focus on their spotlight report on damp and mould, which I mentioned previously from 2021. Mentioned how much of its casework had increased in this area since it put out that report, and these underscored its recommendation in that report that landlords have to take a zero tolerance approach to damp and mould. And interestingly, recommended landlords have to consider a dedicated policy to support decision making and an urgent proactive approach. So landlords should have policies in decision making around how to deal with damp and mould, and that may be a policy that we should be able to get hold of. And the Ombudsman was asking landlords to actively consider whether such a policy was required, and if not done so, and if it wasn't necessary, they had to be clear why it wasn't necessary. Also, I think, which is quite important, was the highlighting of concerns about the tone of communications, going back to the point I made about lifestyle issues, especially languages of lifestyle choices and behaviours that infer blame on the resident and places the onus for resolving the issue on them, absolving the landlord of responsibility. this underlying attitude can impede an effective diagnosis of the causes and timely actions. So I think this should be reiterated to social landlords, that the Housing Ombudsman is of this view if they are using that language, and also that the Housing Ombudsman considers this high type of language patronising, stigmatising and potentially discriminatory, and it's heavy-handed, and therefore may, under section 52F of their scheme, be open to a finding of maladministration. So really cracking down on the use of that language, which is really welcome. The regulator of social housing, they've got a different approach because they actually really hear from, rather than tenants, they hear from landlords primarily about what they're doing. So they wanted to know what landlords were doing in November, and they asked a series of questions about their approach to assessing damp and mould. And I won't dwell too much on what they asked, all very relevant, for time purposes, it's all there. But unsurprisingly, landlords wrote back essentially saying we're doing everything right. They found that most providers responders demonstrated that they are taking damp and mould seriously, identifying and addressing the cases of damp and mould in tenants' homes. They've made improvements in how they handle damp and mould cases over the year. There were a minority of registered providers who supplied poor quality information and lacked the detail they needed to have confidence. You can see, however, the stress is on that there's a minority here. It's very much looking at the proportions of people and the main proportion demonstrating that they're complying. It's very interesting, however, when you look at the data, just to see how many people are actually affected, even amongst this cohort of landlords who are responding, mostly complying. They still have overall 8,000 homes with category 1 level issues, and these are obviously the most serious issues where there's some extreme harm can happen to residents, and there's some immediate danger of this. Category 2 itself is a category of serious harm, and within that category, you have the issue of asthma. And we know from our Bishop's case and from other cases that asthma can be fatal in certain situations. So the fact that 80,000 social homes have category 2 or up to 80,000 hazard is very, very serious. And 160,000 of them have some notable damp and mould, and this is just from what landlords were telling them. So there is I would say, even on this data, a really serious problem. However, hopefully things might now start to move in the right direction. It was supposed to be hopefully a defining point in landlords and making their homes fit for habitation, particularly in relation to damp and mould. And hopefully we can use some of the responses from the institutions in our fight to make sure that our clients have a home that's fit to live in and their rights are enforced. There is some other good news, which is fixed recoverable costs, because of course we have to have funding. And you and all of us have to be able to continue to practice in order to help deliver tenants' rights. And the government has announced that it will be deferring the implementation of fixed recoverable costs in relation to housing cases, that's all housing cases, until October 2025. In a letter from Lord Bellamy QC, he said the government had decided to expand the delay to the extension of FRC to legally aided housing possession claims to all housing cases for 2 years from October 2023. And I would say that this has been due to the fantastic work by HILPA in opposing the extension of FLCs to housing cases and their tireless campaign. to make that happen, which has borne fruit certainly for the next couple of years, and then hopefully by the end of this period we're potentially looking at a new government who might take this issue further, hopefully. Moving on, I wanted to just say a few words about the Renting Home Act Wales. Some of you who are attending may be attending from practices in Wales, but even if not, I think it's a very interesting development for us all to be aware of and to follow how it develops in the future in terms of implementation. The Renting Homes Act Wales came into effect on the 1st of December, and it effectively takes out Wales from the Landlord and Tenant Act as the jurisdiction of the Landlord and Tenant Act, and into its own now comprehensive landlord and tenant, although we won't be using those terms, code. And it replaces secure tenancies issued by local authorities and assured tenancies with secure contracts, private sector contracts with standard contracts, and tenants and licensees are contract holders. The provisions include taking all the main provisions and obligations that landlord keeps dwelling fit for human habitation as well as repair. But in addition, they've got supplementary provisions relating to housing conditions, including a provision a contract holder is not required to pay rent in respect of any day or part day during which the dwelling is unfit for human habitation. But because this is a supplementary provision, then parties can agree to exclude that. There are also regulations describing the circumstances and matters which regard must be had when determining whether dwelling is fit for human habitation, similar to the prescribed hazards in Section 10 of the Landlord and Tenant Act, because they're from the same source, which is the Housing Act 2004. They set out the installations in relation to the requirement for smoke alarms, so set out the requirements in relation to the installation, smoke alarms, carbon monoxide alarms, and provision of electrical condition reports. But in addition, they provide that dwelling will be treated as unfit for human habitation at a time when the landlord is not in compliance with those requirements. And also there is some further protection in relation to notices for possession. Standard contracts, that's mostly private landlords where any of the requirements are not met. And further than that, there's additional protection from eviction where a contract holder has enforced or relied on the landlord's obligations under the provisions for disrepair or fitness, and the court is satisfied that the landlord has made the possession claim to avoid complying with these obligations. And this provision is certainly going to be easier to access for contract holders than the retaliatory eviction provisions under the Deregulation Act, because you do not have that level of reporting that you have in those provisions. So that's going to be very interesting to see how that develops. And now I'm just going to finish by looking at a few cases, just a few cases, some of which are in the update and one that isn't. Environmental Protection Act, this is a costs case. Essentially, there was Mr. Parker brought an action for statutory nuisance in relation to a party wall. He brought it against his freeholder and he brought it against the freeholders of the adjoining property. Liability was admitted, abatement order was agreed, and costs were to be paid. The costs of his freeholder were agreed, the costs of the neighbouring freeholders were not agreed. So they went to court to have that adjudicated upon. One of the neighbouring freeholders, the interested parties in the case, appeared and didn't, and essentially they couldn't pay, and the deputy, the district judge therefore said your liability to costs given your means was £100. So Mr. Parker sought judicial review of that decision. I'll come back to the judicial review point. And Mr. Justice Fordham, as you can imagine, did a thorough examination of the law in this area and explained the questions the magistrate court must address, which are what expenses are properly incurred by the private prosecutor in proceedings, what amount is reasonably sufficient to compensate the private prosecutor for the properly incurred expenses, and if there's more than one defendant, what is fair and reasonable proportion of the expenses that any given defendant should be ordered to pay the private prosecutor. And he found the district judge had erred in looking at costs through the prism of the interested parties' means rather than considering the statutory question, and the means of the defendant irrelevant to whether the expenses are properly incurred. It's possible the court could find the relative resource of the parties of some point linked to those resources could be of assistance in deciding what amount is reasonably sufficient to compensate those expenses. Going back to the judicial review point, of course, the appeal should have been brought by case stated, and the case stated has been brought within 21 days. This didn't happen here, and when it was brought to judicial review, it would have been out of time for case stated. And on that basis, the court could have dismissed the application of judicial review, but on the particular facts, it allowed it, the facts being the point was never actually taken. However, even though that the permission judge had pointed it out, but still allowed permission, and there was a manifest error of law, but obviously you wouldn't be taking, in normal course of things, you wouldn't be taking judicial review in these circumstances. And then lifts. This is a recent case that I wanted to mention just because it helps to clear up confusion sometimes around lifts and whether they're included in section 11. The confusion can be brought about by the way in which section 11 is set up, and the inclusion of the common parts in section 11(1)(b), or the mention of common parts. So this was an assured tenant in a block of a non-profit registered provider of social housing. His tenancy, Mr. Cox provided Anchor would provide the services set out in the schedule, and unusually, because most of our assured tenant clients will not have to pay service charges, unusually he did have to pay service charges for them, for the services, and these services included the lift serving the building. And he argued that under subsections 4 and 5 of section 11 of the London Tenant Act, a service charge clause in the tenancy agreement has no effect insofar as it would require the tenant to contribute to the costs of work carried out by the landlord, which falls within the landlord's implied repairing obligations, and therefore this applied to charges in respect to the lift. That should be. The first tier tribunal found that the lift was a common part or common facility and engaged section 11(1)(b) through the definition of common parts. In section 60 of the Landlord and Tenant Act 1987, which covers any common facilities in the building, according to the first tier tribunal, and it was an installation which indirectly served Mr. Cox's flat, although it was not mentioned specifically in section 11(1)(b). It fell within that limb because in the context of the building, it was an essential installation, and the upper tier tribunal overturned the decision. Essentially, they were saying that while the lift is an installation, I won't go through the whole quote, it's not an installation for the supply of water, gas, electricity or sanitation of the space, heating or water, and so it doesn't fall within subsection 1(b) or 1(c). Subsection 1(a) only extends those installations, if they're in the building but serve the dwelling. And the FTT treated subsection 1(a)(b) and 1(b) as applying subsection 1(b) to any installation which is a common facility. And that interpretation was not justified. In fact, what 1(b) does is it limits the installations for the supply that are properly covered, qualifies them, if you like, so that only arises if the disrepair affects the lessee's enjoyment of any of the dwelling house or the common parts. It doesn't bring installations in common parts within the repairing obligations per se. Now moving on to quantum, Obviously, we had the case of Khan and Mahmood last year. This was a case which clarified, if clarification needed, which obviously it was for some landlords and some courts, that claims for general damages for breach of the repairing covenant fall within the primary purpose of the 10% uplift in Simmons and Castle to compensate successful claimants as a class for being deprived of the right to recover success fees from defendants in cases where a claimant was funding legal costs of pursuing their claim by a conditional fee agreement. Okay, there is case law which establishes the fact that Simmons and Castle also applies to legally aided claimants. So the fact that they're just referring to conditional fee agreement in this part, or I have only referred to it, doesn't mean it just is limited to cases brought on conditional fee agreements. And that again is brought, or that achievement has been come about through the intervention of HIPAA, in great part, sorry, and so we've got something else to thank them for, and clearly the cost benefit kind of analysis of being a member of HIPAA is very much on the side of membership in what they've managed to achieve this year, which has been great for claimants. I then want to mention Adioc and Peabody Trust, which is a case of Patrick's, who's going to be speaking in a moment, because this, although it was a settlement case, it's a case involving asthma and housing disrepair, and it's very helpful when looking at the amount of damages one might get and indicating the importance of expert evidence in achieving the appropriate damages for the particular case, and then how one goes about estimating what the appropriate quantum might be by reference to the Judicial College guidelines. And in that case, the parties settled on then damages of £40,000. So that was a great result there for the client. And finally, and very quickly, I just wanted to mention one of the cases that is in the disrepair upgrade, which is JH and Camden Borough Council, for two reasons. Firstly, because it deals with enforcement of Tomlin orders and damages for breach of those orders. Tomlin orders routinely, with some local authorities particularly, are not adhered to, and in this case, having failed to carry out the outstanding repairs, an application was made to enforce the terms of the Tomlin order. At that hearing, the court made an injunction order on the same terms as the schedule of the Tomlin order. An application was also made for a penal notice to be applied. Often courts, very often, and mostly courts don't give penal notices in the first instance, but the issue can then become, if you have to come back to court, you may not get a hearing for months and months and months with still no work having been carried out. So what is always useful to do is, if the court isn't going to mind you to give a penal notice, is to ask the court to set a date for a hearing to consider a penal notice if this intransigent, seemingly intransigent landlord still hasn't set to work, and therefore that's the sword of Damocles hanging over them, that a penal notice is very likely to be made if they don't get on with it. And then a damages hearing was listed, and the general damages were awarded for the notional market rent from the date works should have been completed under the Tomlin order until the date of the hearing, which was 9.5 months. And interestingly, the damages were awarded for the full 9.5 months, even though the tenant wasn't occupying the flat, because they had decanted as part of the agreement in the Tomlin order. Nevertheless, they were given damages during the period they weren't occupying, and that was based on the principle in the case of Marjani, which the principle there is that loss in these circumstances, what you're losing is a measure of the impairment of the right of amenity afforded to the lessee by the lease, i.e. them keeping to their obligations. And distress and inconvenience are only symptoms of that loss of amenity. So while you might not have the same level of distress and inconvenience because you're not living at the property anymore, the fact that the property remains in disrepair is still a breach of the obligation, and you're still an impairment of that right of amenity, and therefore you should be compensated for it. So obviously you're not going to get the same level of compensation outside of the property as if you're in the property, but you're still entitled to it. And so on that note, which is another positive note, that's my talk. If there are any questions, then please put them in the question and answer, and myself or Patrick, and we'll deal with them then. So I'm now going to stop sharing. Thank you for listening, and hand over to Patrick.
Yeah, thank you. Thanks, Catherine. Yeah, I'm just going to get my screen, share the screen. Make sure it's on my emails. Yeah, nearly there. So I think everyone should be able to see that, I hope. And that's the first page. So yeah, so I'm going to be talking about practice and procedure in terms of personal injury in regard to disrepair, and particularly within that, an asthma claim arising from damp and mold. It's going to be very sort of practically orientated in terms of, you know, sort of practitioner's view. And I'm pitching this really as a reminder to housing lawyers about the sorts of issues you need to think about. I'm conscious that, you know, many housing lawyers don't spend a lot of time necessarily day to day dealing with personal injury, obviously other than arising out of disrepair, and often and not always does it arise in claims for disrepair. So, and also just before I start, just to emphasise that the vast majority of personal injury claims settle before they get to court. I suppose you could say that's the case with a lot of disrepair cases as well. But in the case of personal injury cases, of course, a lot of those settlements will be without the case ever being issued, ever being a claim ever going into the county courts. Whereas, of course, with housing disrepair, that can happen quite frequently. It's just obviously bear that in mind. So if I move on to my first slide, so just a very brief reminder of the law that's applicable here in terms of personal injury. As you all know, it's a mixture of contractual rights under the tenancy, express and implied, section 11, section 9A, and so on, and then tortious duties existing by virtue of the law itself, and not dependent upon any particular agreement. And of course, that reaches other classes of claimants, including children, other members of the household, and visitors. And in that respect, everyone will be familiar with the Defective Premises Act, which imposes a duty to take care on top of the repairing obligations that landlords have. I won't say anything more about the DPA. You've got the Occupiers Liability Act, which will deal with common parts, common law negligence. It's worth just pointing out on common law negligence that you may have claims arising out of refurbishment or defective refurbishment works by the landlord. For example, where they've installed a new staircase or a step, but forgotten to put in a handle for the tenants to use, and they've created a hazard which you can use to pursue the landlord for breach of duty if an accident arises. At the very bottom, sorry, at the bottom there, I've just mentioned the EPA 1990. Don't forget that under statutory nuisance, if there is a successful prosecution, the magistrates do have the power to award damages, including for personal injury. But obviously, as most people will know, that is restricted still to 6 months only before the information is laid. That's not to say it might not potentially have some value, though, certainly in the case of an asthma where the prognosis is uncertain or as I said there, colloquially bad. The limitation dilemma, again, I'm not going to spend much time on this other than to flag it up to people because everyone will know about this. You've got the conflicts between the 3-year limitation for the personal injury against the 6-year limitation under the tenancy. Of course, it's 12 years if it's a long leasehold. And just a few pointers there. You want to, you're going to be balancing up the claims in terms of their value. And that's going to be a theme actually of my talk, really, that you really want to get to grips with quantum right from the off. You want to be getting a sense of what the potential personal injury case is going to be worth based on your experience, based on quantum reports and so on, that you can make an assessment of, hopefully from the first instructions you get from the client or shortly thereafter, because so much is going to flow from that valuation in terms of where the case ends up, in terms of procedure and so on. So, and I've put a, yeah, I mean, one of the points here I just wanted to flag up is the, are you going to pursue one claim for disrepair with the personal injury within that? Well, we'll come on to that in a minute. Obviously, it's only going to apply if it's low value. What I have found in recent cases that I've done is that certainly social landlords will want you to separate them out as potentially two claims, certainly to start off. And the reason, as far as I can judge for that, is that often social landlords will have public liability insurance with a big insurance company like Zurich for the personal injury claim, and they will meet the costs and the damages under that insurance policy against the damages and costs for the disrepair action, which are more likely to fall not on an insurance company, but on the housing budget of the local authority or the resources of the housing association. So it may well be that you've got a landlord who wants to play along with two claims. So step one, you've got the client in front of you and you need to get some evidence together. And again, this checklist here is going to be, I'm not going to go through it in any detail because it's going to be very familiar to everyone, I'm sure, in terms of the things you need to be aware of, in terms of gathering that first tranche of evidence and data about the case. What I would say is that when you're taking the client's proof of evidence in the first interview, do make sure that you directly ask the question and prompt them as to whether or not they've had any ill health or accidents arising out of the disrepair, and what those symptoms are when it commenced, what they attribute it to, whether they attribute any aggravated asthma, for example, to bad mold and damp in their bedroom that affects them, particularly obviously at night. And then ask them about the impact that has on them day to day in terms of the activities of daily living and their ability to cope from day to day. Obviously, you've got to deal with any children or other household members who may also be suffering in damp and mouldy housing and struggling with aggravated asthma. And that again comes back to your assessment of the value of the claim and quantum. And without that basic information at the start, you're not going to, it's going to be more difficult for you to, or it's going to be impossible for you to sort of gauge where it's going to fall, that case, in terms of tracks and so on. GP notes. So I've put an asterisk there because the next slide, I've extracted here some quotes from a set of GP notes on one case I've dealt with recently. You'll see they're 6 months apart, these two entries. These are entries made by the GP, and you'll see they record what the patient or our client said at the time. And in this case, it was, you know, essentially bingo, really. As you can see on the second appointment 6 months later, the patient records that the patient is living in a flat with mold and damp exacerbating asthma symptoms dramatically. Well, there you're thinking that we've got a case here that is going to stack up in terms of causation. And just my note there at the bottom, and it goes back to the first appointment you have with the client. If the client says to you, well, yeah, I have had bouts of coughing and lots of colds over the last 12 months out of the normal. And either I haven't mentioned it to the GP, or if I have mentioned it to the GP, I haven't related it to my housing conditions. Well, you need to advise the client to make that appointment after they've seen you, to go to the GP, or these days more likely to have a telephone appointment, and make sure that the GP records that the ill health is and or may be related to the housing conditions, and get the GP to record mold and damp on the record as a contemporaneous note that will serve the claimant well if they subsequently, and if we recommend that they pursue a claim for personal injury. Once you've got your initial instructions, you're going to move on to doing a risk assessment. Now, I mean, all PI cases, personal injury cases, these days are going to be run under a conditional fee agreement, and typically you're going to have to sign off a risk assessment where you, and normally you get that countersigned by a colleague, where you find that prospects of success are going to be 60% or better. You're unlikely to get any after the event insurance unless you can give reach that view. You are clearly going to, in an asthma case arising out of damp and mold, at the forefront of your thoughts is going to be the question about causation. And that comes back to the things I was just talking about in terms of GP notes and other evidence. Assessing quantum. Once you've, as part of the risk assessment, you're going to be assessing quantum. You want to know if this is going to be a multi-track case, if it's going to be worth over £25,000, or is it going to fall into the fast track? How's it going to fall into the fast track? Well, you're going to have to find general damages for the personal injury element exceeding £1,500. Now, I would say in asthma cases, that shouldn't really be very difficult. I would say in most cases, in fact, less than asthma cases of respiratory problems reported to the GP over a period of months, you've got a good chance of getting well over £1,500 in terms of general. So there's a good chance most of these cases should get onto the fast track. I think that also tells you that you're going to be using not the housing conditions protocol, but you're going to be using another protocol to pursue it. I'll come on to that in a minute. Advising the client about funding options and costs. We've got professional responsibilities, of course, as you know about that, to make sure you explore whether they've got alternative means of funding the case through household insurance or trade union membership, and as alternatives to funding on a CFA. Keep, and I've put that in bold, keep accurate attendance notes of what you've told the client about their funding options, because when the client signs up to the CFA, they've got to do it on the basis of they've done it in an informed way. They're aware of what the options are, and they've made a conscious decision on your advice to sign up to CFA. And that's good. That responsibility is going to be heightened in the case of children, which is why I've made reference there to CPR Practice Direction 21, paragraph 11.3, which I'll come on to in a bit. The success fee, what success fee are you going to set? Well, talking about my own firm, and I think this is common across the personal injury sector, generally now you get a stepped approach to the success fee depending upon the position you are in terms of the litigation. So in terms of my firm, for example, the sort of default position is to set the success fee at 25% if you, that's 25% uplift on your basic charges. That's what the success fee is. Sorry, just to be clear about that. 25% before issue of proceedings. So if the case settles before you've had to issue proceedings, the success fee will be 25%. 50% if you issue proceedings, and 100% if it goes all the way to trial. And bear in mind, or remind yourself that that, of course, is subject to the cap, which is 25% of the recovered damages. But it's not all the damages, it's only going to be the general damages and past pecuniary loss. You can only take 25% out of those items of damage recovered. AEI, that's the after event insurance policy. I would say that for asthma cases where you're always going to be fretting about causation and worrying about, am I going to get a medical report that's going to support the case and make it a runner or a winner, you're going to want after the event insurance. To my knowledge, most personal injury practices will have that. The only one that we offer is the one under the Abbey legal scheme. That used to be the accident line scheme, goes back 25 or more years. And for members of the scheme, we have what's called devolved authority. That means that we can issue the policy. We don't have to make a particular case each time we want to issue a policy on a claim. We have devolved authority to issue the policy. And that comes with premiums attached, which are deducted from damages upon successful conclusion of the case. Remember, the premium, of course, isn't payable if the case is unsuccessful. If the case is unsuccessful, you're potentially going to be making a claim against the policy. And under the policy will also write off the notional premium that otherwise would be paid if it was successful. What does the premium cover? Well, it's going to cover your disbursements, the medical reports, which, you know, on an asthma case, if you're instructing a consultant physician, you could be paying, you'll be paying at least £1,000, £1,500, £2,000. So quite a lot of money. The court fees and any costs awarded to the defendants potentially will come, will protect your clients under that policy. So if I move on to the protocols, so you've done your risk assessment, you're about to start the case, you want to do a letter of claim and put it to the defendant and put it to the defendant insurers. So your starting point is going to be the housing conditions protocol. This is very familiar, I'm sure, to everyone. Basically, as it says, if the personal injury claim is of a minor nature and will only be evidenced by a GP letter, it's not necessary to follow the PI pre-action protocol. But obviously, if it's otherwise, if it's not a minor nature, and if you're going to need more than a GP letter, you're going to be looking at other protocols. And it says here the PI pre-action protocol, but it's a bit more complicated now. And in fact, really, the protocol here perhaps ought to be updated, because if we move on, we've now got the low-value personal injury protocols. There's one for road traffic accidents, but there's also this one for employer liability and public liability claims. And of course, it's public liability claims that an asthma claim would potentially fall under against a landlord. I've put here the scope, clause 18 from the protocol. Why have I done that? Because what it says is that if the claim is arising from a disease that the claimant is alleging that they've contracted through a breach, and that's obviously going to be potentially an asthma claim, then arguably, well, it says specifically it shouldn't be pursued under the low value PI protocol, and that instead what's clear is that this protocol is there to deal with a one-off event, a particular accident, a point in time, and that disease claims have to go elsewhere. The case that Catherine referred to, my case, which is reported in the legal action, I actually mistakenly started it under this protocol myself. In fact, it was the insurers who put me right and said, no, you're wrong. It needs to go under the pre-action protocol for disease and illness, which from a cost point of view, as you'll find out, is a relief. And it's a lot less bureaucratic to have to use as well. So asthma claims are going to fall under this protocol, I would say. And I've highlighted a few of the key points there. And you'll see at 2.4, it says the protocol is not limited to diseases occurring in the workplace, but will embrace diseases occurring in other situations, for example, through occupation of premises. Well, obviously that's tenants or the use of products. But it's tenants we're interested in. So the advantage of using this protocol is it's a lot more relaxed in terms of how the parties can communicate with each other. And one illustration of that is how that protocol deals with experts. It talks about at 9.4 in the protocol, recognizing that a flexible approach is needed in relation to these types of cases. And for example, it says there will be many occasions when the claimant will need to obtain a medical report before writing the letter of claim. And obviously the main reason for doing that is the question of causation, because if you haven't got a medical report that will support and make a finding of causation, your case is not going to succeed. The claims portal, I've put this in because people may be confused about where this stands and everything. Well, just to be clear, the claims portal, I've just got that bit in italics. I've taken that off the website of the organisation that runs the claims portal. And it is simply an online method, as is very common now, of course, in other fields, of sharing information between parties in relation to a claim, including documentation such as medical reports and between claim lawyers and insurers and compensators. The claims portal, it has to be used if you're relying on if your case arises out of the low value protocol that we were talking about a few slides back. Basically, the protocol deals with claims worth up to £25,000. And it's designed, the claims portal is designed to deal with the cases where liability is going to be admitted or likely to be admitted by the defendant. Once you've got admission of liability through the portal, you then have a process of the claimant making an offer by way of a settlement pack and the defendant or the defendant insurer making counter offers, and you bat it forwards and backwards in an attempt to reach a settlement. And that's, so stage one of the claims portal is about liability. Stage one lasts for 8 weeks. So you put the claim up on the pro forma, the claim notification form, as it's called. It's quite easy to use. And once it goes to the insurer, assuming you've got the insurer's name and the policy number, you may have to get the landlord to give that to you. You can't otherwise, well, they're going to have to provide it to you. Otherwise, you're going to have to send it directly to the social landlord in the post. You won't be able to use the portal. But anyway, the time allowed for liability to be considered by the other side is 8 weeks. If they don't respond and admit liability within 8 weeks, the claim falls out of the claims portal, and it falls out of the low value claims protocol and falls under the PI protocol, where of course the time limit's to 12 weeks. So there's an additional 4 weeks, 8 weeks plus 4 weeks equals 12 weeks to allow the defendant to consider their position on liability before you're free then to issue the claim, unless you're up against limitation, of course. Just also to mention, if you've got a claim, it's unlikely to, sorry, just that bit in brackets I've put at the top, just to emphasize, you're not going to be using the claims portal for asthma claims, but you will be using it for other claims arising out of disrepair. A broken step, for example, arising out of disrepair, where your clients put their foot through it and fractured their ankle, for example. Stage 3, so you've got stage 2 is where you try to agree settlement. If you can agree settlement, the case stops at that point and you get your fixed costs, which are atrociously low. Those fixed costs, which I've put in there, have been fixed since 2013. I don't know what they would be now with inflation, but they'd be a lot more. And you can see the fixed costs are related partly to the value of the claim and also the stage they reach. So 1600, just to give you an example there, 1600 is if it's, yeah, that's if it settles at stage 2 and it's valued at more than 10,000. 900 if it's worth less than 10,000. If you can't reach agreement, there's stage 3, and that's set out in practice direction 8B. And basically, it's a Part 8 claim to the court where you have to file the settlement pack with the positions of each parties set out in terms of what they say case is worth with the evidence and support, and then the court will make a decision either on the papers, probably most likely, possibly an oral hearing. In person. Yeah, I mean, just to also say that other ways that the claim can fall out of the claims portal will be if you revalue it and you say, no, it's worth more than 25,000, you're entitled to take it out of the portal. If contra neg is alleged, and obviously if it's a disease claim, an asthma claim, it really ought not to go anywhere near the claims portal. Child settlement, I've put in 2 slides here, CPR 2112 and CPR practice direction 21. Why have I done that? Because a lot of PI cases arising out of disrepair are likely to be for children, certainly in terms of asthma. And of course, in the case of children, we're going to have to go to a child settlement hearing in front of a district judge. And the district judge, once they've decided that the level of damages is appropriate, is then going to have to deal with the question of costs. And because the success fee and the insurance premium are now no longer recoverable from the defendant insurer, the success fee and the insurance premium is going to have to come out of the damages, as you know. And the importance of these parts of the rules is it sets out the procedure by which you put that to the court to try and persuade a district judge that the costs, including the level of the success fee, including the level of the insurance premium, have been, quote, reasonably incurred, and, quote, are reasonable in amount. Okay. And how are you going to do that? Well, paragraph 11.3 of Practice Direction 21 sets it out for you. In preparing for the settlement hearing, you're going to have to prepare a detailed witness statement on behalf of the litigant in person, dealing with all of those points there. And you're going to have to exhibit all of the, the CFA, the risk assessment, and the reasons why the particular funding model was selected, and so on. So it's pretty onerous. And my suggestion is that you practitioners may well want to cut and paste 11.3 and stick it on your wall as a useful reminder when you're right from the day you're starting a case as to what you're likely to end up having to justify in front of a district judge if you're trying to get your successfully deducted from the child's damages and also the insurance premium. Moving on to quantum, I've got here some quoted extracts from a medico-legal report prepared last year by Dr. John Collins, which I think practitioners will find helpful in understanding how asthma can persist. And I mean, I think what I find particularly helpful in terms of the opinion here of Dr. Collins, and the bits I've highlighted in red, I think are very useful. He says, point 3 there, quotes, the increased severity of asthma caused by mold and damp may persist even when exposure to those conditions ceases. And he goes on under point 5, mold and damp are recognised as potent causes of duration and severity of asthma, and asthma may persist indefinitely after the individual has been freed from further exposure to those conditions. It's clear the point he's making there is that even after the damp and mold has been removed and the house is in a habitable state, or the tenancy is in a habitable state, there is likely to be uncertainty about the future prognosis of the asthma. In other words, it may well persist once you've been exposed to those conditions. It's not just necessarily going to clear up. And that's going to be relevant, highly relevant to quantum, of course. And on quantum, where are you going to look to advise the client? Well, you're going to start off by looking at the Judicial College guidelines. The most recent edition is the 16th edition from last April. And here I've cut and paste chapter 6, injury to internal organs, section D. Section D specifically deals with asthma. And I think that the notes here and the description given here does pay careful reading by housing lawyers. I say that because it comes back to the question I was saying towards the top of the talk, is that you want to make an early assessment of quantum. And you're only going to be able to do that if you've got some grasp of the likely level of award by reference to judicial authority. And the starting point there is the guidelines. And you can see there, starting at the bottom, little e, mild asthma, bronchitis, colds and chest problems, which might only last a few months and be evidenced by, treated by a general practitioner only. We're talking about up to £5,000. So that's well above the £1,500 threshold for getting onto the fast track. The next one, relatively mild asthma-like symptoms. So it may not quite qualify as asthma, but it's asthma-like symptoms. You're talking about up to 20,000. And it goes on up there, as you can see. Next one, exposure where you may there may be substantial recovery within a few years of the exposure to the cause, up to 26,000, and up to more serious cases towards the top. But I've highlighted there in B, chronic asthma with uncertain prognosis, and that sort of goes back to what Dr. Collins was saying on the previous slide. Uncertain prognosis, you're talking about up to 40,000 and above. So these are clearly multi-track cases. And just to finish off, once you've looked at the guidelines, you really want to get out some quantum reports, and the classic quantum series is Kemp and Kemp, at least it is for PI lawyers, published by Sweet and Maxwell. And this is a case lifted from section K, which deals with internal organs in relation to asthma. It's a case decided in 1996 in Liverpool County Court. You can see the details there. And under PSLA, for those who don't know, stands for pain, suffering, and loss of immunity. It's general damages. And for the tenant, it was valued at, well, she recovered £10,000 back in '96. Uprate that for inflation and add the 10% Simmons uplift. In today's money, that would be 23,000. And for the child, you can see on the right-hand side, £5,000, where the child was reporting constant chest infections and mild asthma. Mild asthma, arguably, that might have been undersettled by reference to the judicial guidelines today. So that's my talk. I mean, just to finish off, I think it's clearly, and as Catherine was showing in terms of the statistics there, there's a lot of essentially unmet claims, I think, out there. And I think there's an opportunity for practitioners more actively now to pursue personal injury claims. I think doctors, GPs, hopefully are going to be a bit more aware of housing conditions and damp and mold and its impact on people's health because of the reported terrible case from November last year. So I'll finish there. Thanks.
Okay, thanks very much, both to Patrick and to Catherine. Really insightful talks, which I hope has been of some benefit to all of the participants that have joined us today. We have got a few minutes for questions, so I'm just going to kick off with a couple that are in the chat. Please do feel free to put ones in the chat if you can think of any now, and we'll try and spare some time to deal with it. So the first one is, I think, directed at you, Patrick, from Andy, and he has asked, isn't there a problem with res judicata if you run separate disrepair and personal injury claims arising out of the same facts? You're on mute, Patrick.
Well, I think the short answer is yes, there is an issue. If the defendants want to sort of make a point about that, they can, and how to deal with it. I mean, what I find is that the disrepair case will run ahead of the personal injury case invariably, and it's possible that you're heading towards a hearing where you want to get an order for an injunction or a specific performance order to get the works done, and your PI case is still way behind. And I think you just have to make an application, don't you, to the judge to say, look, this is the position. We want to reserve our right to join the PI case when we're in a position to do that. But in the meantime, we need to sort out the conditions in the property and the disrepair and the damp and mold.
So you'd suggest joining or consolidating perhaps the two claims once both were up and running?
Well, I think that's right. There's got to be, yeah, I think that's right. Otherwise, you are much more at risk if you don't draw the court's attention to the personal injury case. Then you are running a risk, aren't you, that you're going to fall foul of, and it's going to be, issue a stoppable. And why didn't you pursue this as part of the disrepair action, and or make the court aware that you were running a separate personal injury case, and it could be provided for in the order?
Yes, I mean, I suppose I could just add, as my role as a deputy district judge, I would certainly want to know in a disrepair case if there was a separate personal injury case, so that both orders on both cases could actually sort of reflect what was happening in the other one, and potentially make way for a consolidation, or at least being heard at the same time. So from a judicial point of view, I think that's absolutely the right way forward. Okay, I'm going to move on to another question. Catherine, I think this is aimed at you, again from Andy, actually. So what Andy has said is, how do the government expect local authorities to enforce new damp and mould provisions, given that they don't currently have the resources to carry out any meaningful enforcement of the existing hazard breaches? So I don't know if you, clearly you're not here representing the government, but I don't know if you have any insight into how, as practitioners, we can get round the fact that, there is very little enforcement going on in these types of cases.
No, absolutely, and I didn't want to appear too cynical while I was giving the talk as to whether or not any of these things would work. I mean, they're all great plans, but that's exactly what local government is going to say. And this has, and maybe there'll be some streamlining, maybe there'll be some more money put in. There'll be the streamlining of enforcement with the kind of, the HMO kind of licensing. There may be more of a move towards licensing of private landlords, so that the kind of discretionary licensing schemes that local authorities can take up, if they're allowed to, which may have housing conditions as part of the requirements for a license. So yeah, I mean, there's lots of movement around things that could be done for reorganisation, but essentially the funding has to come from somewhere, and we do know that how difficult it is to get an EHO out for an EPA case, or for any case. And of course, they don't inspect local authorities anyway. So yeah, so I think we're just going to have to wait and see is the answer for that. And the resources are going to be the big issue. Certainly we can legislate what we want, but yeah, having someone come round to actually do that assessment is going to be key. But no, I don't know how they're going to do it, and the track record isn't great, but fingers crossed.
All right, thanks, Catherine. Couple of questions going back to Patrick. Firstly, on limitation, how is it best to mitigate the limitation issues for adult claimants? It's been mentioned by the person posing that question that the problem they have is that clients often take years to approach solicitors because they've waited for their landlord to address the issues, and of course that never happens. And then of course by the time it comes to us, there's chronic limitation issues. And just as an additional question to Patrick, how do you fund getting the medical reports? So perhaps take limitation first and then deal with the funding of the medical reports.
Well, if we're talking about limitation in regard to asthma, it seems to me that if damp and mold is still prevalent, then it's an ongoing breach. And although and if it's been going on for years, at the time they come to consult you, that there may, you hope, still be, you're expecting that the damp, they're coming to you because they've still got damp and mold. They need injunctive relief ultimately, if necessary. And in terms of the personal injury, you know, limitation doesn't really apply in those circumstances. So I don't know if that answers the question, but I mean, I think in terms of asthma, I think that's how I would deal with that. But the point about medical reports, how do you fund medical reports? Well, talking about my firm, and I think most PI firms, we fund it out of, you know, our own resources, and we don't, I mean, very occasionally you might get a client who's willing to make a payment on account, but the vast majority of disrepair cases, that's just not going to be a practical proposition. So we would fund the medical report. Sometimes you'll get a medical expert who's willing to defer the fee, but if not, we'll pay it. And we'll pay it in the knowledge that we've also got an insurance policy. After we make an insurance policy, if that report doesn't stack up on causation, if we can't use the report to pursue the case, then we're going to have to make a claim against insurance policy. That's how we get the money back. Yeah.
Okay, thanks. I hope that's answered the question. We've got a question from Oliver. Both of you might want to respond to this, but a hypothetical but common scenario, client is housed in accommodation, Part 7 accommodation. Sorry, I've just got to keep changing this, because when someone puts in a question, I lose what I'm reading. So the client is housed in Part 7 accommodation or Immigration Act accommodation, Section 95. They occupy on the basis of a license. If, for example, they were injured caused by a defect in their room or their accommodation, would it be the Occupiers Liability Act? What's the cause of action? Patrick, do you want to go first on that, and Catherine, add anything if you wish?
I mean, my gut feeling is you're talking about the Occupiers Liability Act. It's about control, isn't it? Yes, it's a license, it's a bare license. Yes, yeah, you're in a hotel room in effect, aren't you? And you don't have any control over that space beyond using it. You're not providing any furnishings or doing anything more than living in it. So yeah, I think it's the OLA.
Catherine, do you want to add anything else? Any other cause of action you might think may arise? Probably not if it's
I just wanted, yeah, the Occupiers Liability Act, a common duty of care to take such care as is reasonable in all the circumstances to ensure the visitor be reasonably safe when the premises for the purpose of which he or she was invited. There's also potentially an implied term that for licensees in relation to safety. I was just going to look that up, but there's also, yeah, potentially implied term for a dwelling houses held under a license. With a license and not a tenancy, a term may be implied into the license requiring the licensor to take reasonable care to ensure that the condition of the dwelling does not cause personal injury to any of the occupiers or damage to the property.
So an implied contractual term there.
Yeah, if it's a contractual license, then potentially an implied term also.
All right, thank you. Probably got time for one, maybe two more questions. So the next question is aimed really at sort of costs, but I'm going to read it all out. It's from Anonymous, so I don't know who's posted it, but if there's a non-asthma or disease type claim, for example, a client suffered a burnt foot as a result of a pipe bursting, but they also had a general Section 11 claim. This poster said that they then follow the low value protocol, where there are fixed fees. Will that prevent you getting costs in respect of the general damages, the Section 11 claim? Patrick, I don't know whether you can talk about the interplay between the two types of protocol and claims.
I mean, you've got the personal injury, haven't you? You've got the burnt foot, and then you've got general damages for the loss of amenity under section 11. That's discomfort and inconvenience. And I would say that general damages under section 11 could be pretty low, because if it's only for a very short period of time, this burst pipe, and if there's no other consequence from it in terms of being flooded out for months on end, then your general damages for loss of amenity are going to be low. Sounds to me like the value in that claim is probably going to be a personal injury case, the burning to the foot. I don't know if that answers. Yeah, and you're going to be, certainly the case is worth less than 25,000, then, and if it ends, as it may well do, under the low value protocol, it's at stage 2 or stage 3 because they've admitted liability, then you're going to be stuck with the fixed fees. But don't forget, you've also got the success fee that you're going to take out of the damages from the client. And although the fixed fees are low, generally speaking, we find it still makes economic sense to run many cases, because unfortunately, the claimant will have to pay a reasonable proportion of the damages to make it commercially worthwhile doing.
Okay, I think just one final question. I just want to answer Manji. Yes, slides will be given out from this webinar, so don't feel that you have to screenshot every slide. We should have probably said that at the beginning, so I apologise that I didn't. So one final question: what happens if the tenant died whilst the disrepair claim was still ongoing? Can the grandson or son continue with the claim with the CFA signed by the tenant? Solicitor asks for evidence from the grandson or son for evidence that he can continue with the claim. So really it's what happens when a party to the claim dies. Patrick or Catherine? Catherine, do you want to come in on this?
I haven't had that scenario, so I can't say. I know that kind of a cause of action, the estate can inherit a cause of action. I'm talking generally from general legal knowledge rather than anything specific. So it's something that you might want to look into. Yeah,
well, you can apply for letters of administration, can't you? On behalf of the estate, for someone who's a relative who's in a position to represent the estate, I guess. I mean, I'm not an expert at all on that, but and yeah, and you can assign the CFA. If you already signed a CFA, you can get it assigned, and also alternatively, you could sign a new CFA, arguably as well.
But on a practical note, I assume that the grandson or son would have to be in a position whereby they could sort of give evidence as to what loss of amenity or inconvenience or distress was caused if you haven't already got a signed witness statement.
Yeah, no, I mean, that's a good point. Yeah, I mean, that's a question of what evidence have you got to support the claim, isn't it? Yeah.
All right, so always take a witness statement and get it signed if you have somebody come in to save any problems later on for whatever reason.
Yeah, absolutely.
All right, well, I think that's all the time for questions. So thank you everyone for joining us. And we do, as I say, give a great deal of thanks to our guest speaker, Patrick, and to Catherine. The slides will be sent out. So we hope this has been useful to you. Thank you very much, everyone.
Thanks.
Thank you.
Bye.
Thank you.
Bye-bye.